India is home to every major religion in the world: Hinduism, Islam, Christianity, Sikhism, Buddhism, Jainism, Zoroastrianism, and many more. Millions of people with billions of different beliefs and practices. How should the state relate to all of this? The framers of the Constitution chose a uniquely Indian form of secularism, not the American model of strict separation where the state has nothing to do with religion. India chose positive secularism. The state does not wall off religion. It engages with it. It protects religious freedom while also retaining the power to intervene to remove social evils that operate through religious justification. Articles 25 through 28 define this relationship in four separate but connected provisions. Article 25 gives every person, not just citizens, freedom of conscience and the right to freely profess, practice, and propagate religion. This is an individual right. Three aspects of Article 25 are important. First, the right covers professing, which means stating your beliefs; practicing, which means performing rituals and religious acts; and propagating, which means spreading your faith to others. The word propagation was specifically included by Dr. Bhim Rao Ambedkar. It means you can try to convince others to adopt your religion. But propagation does not include coercive conversion. Second, Article 25 is subject not just to public order, morality, and health, but also to other provisions of Part 3. This means your religious freedom can be limited by other fundamental rights like Article 14 on equality and Article 17 on untouchability. This is what allowed courts to use equality arguments to challenge religious practices that discriminate. Third, Article 25 expressly says that Hindus for the purposes of this article include Sikhs, Jains, and Buddhists. This has implications for temple entry laws. Article 26 gives every religious denomination the right to manage its own affairs. This is a collective right of religious groups, not an individual right. A denomination can establish and maintain institutions for religious and charitable purposes, manage its own affairs in matters of religion, own property, and administer property. The crucial difference between Article 25 and Article 26 for exams. Article 25 is subject to public order, morality, health, and other fundamental rights. Article 26 is subject only to public order, morality, and health. It is not subject to other fundamental rights provisions. This means a denomination's collective right to manage its affairs is somewhat more protected than an individual's religious freedom. Article 27 says no person shall be compelled to pay any taxes whose proceeds are specifically appropriated for the promotion or maintenance of any particular religion. The state cannot use your tax money to fund a specific religion. Article 28 says no religious instruction shall be imparted in any educational institution wholly maintained out of state funds. A school funded entirely by the state cannot teach religion. Now the essential religious practices doctrine. This is one of the most important judicial doctrines in Indian law and is directly tested in UPSC. Not everything a religion does is automatically protected as a fundamental right. The Supreme Court uses the Essential Religious Practices Test to decide which practices are protected. The test says, only practices that are essential and integral to the very core of a religion receive constitutional protection under Articles 25 and 26. Peripheral practices can be regulated. The challenge is deciding what is essential. Courts look at religious texts, traditions, and scholarly opinion. But critics argue that courts, which are secular institutions, should not have the power to decide the theological essence of a religion. The Sabarimala Temple case of 2018 is the most prominent recent example. A 5-judge bench held 4-1 that the practice of excluding women between the ages of 10 and 50 from the Sabarimala Temple is not an essential religious practice of Ayyappa devotees. It is social exclusion, not a core religious tenet. The majority held the exclusion violated Articles 14, 15, and 25. Justice Indu Malhotra dissented, arguing courts should not interfere in religious beliefs even if they appear discriminatory. The case has been referred to a 9-judge bench which has not yet delivered its final decision. The triple talaq case of 2017 held that instantaneous triple talaq is not an essential practice of Islam. Now your MCQ. Which of the following correctly distinguishes Article 25 from Article 26? Option 1. Article 25 is a collective right of religious denominations, while Article 26 is an individual right. Option 2. Article 25 is an individual right subject to public order, morality, health, and other fundamental rights, while Article 26 is a denominational collective right subject only to public order, morality, and health. Option 3. Both Articles 25 and 26 are subject to identical restrictions, including all other fundamental rights provisions. Option 4. Article 25 applies only to citizens, while Article 26 applies to all persons, including non-citizens. Think carefully. The correct answer is Option 2. Article 25 is an individual right available to all persons. It is subject to public order, morality, health, and other fundamental rights provisions. Article 26 is a collective denominational right. It is subject only to public order, morality, and health. It is not subject to other fundamental rights provisions. This difference is directly tested. Options 1 and 4 have the descriptions reversed or wrong.